to part 3 of the Smartphone Investigations webinar series. We're glad to have you with us on this, cloudy here Thursday afternoon. I'm going to go ahead and turn it over to our presenters, Amber, and other guests. So go ahead and...
Hi there, everyone. We actually have 3 of us this week. I've asked some colleagues to join for the final session, which is our presentation session on how you actually share the data. So let me get this going. Does that infinity thing that we have all gotten used to. And here we go. So you guys have already known me from the other sessions. I'm Amber Schroeder. This session is specific to presenting some of the data that we've talked about. So, of course, we see all of our smartphone data kind of go through a variety of different crimes that we might deal with, whether we're public sector or we're private sector. We're going to deal with different parties associated with it. So instead of going through and looking at it from our 3 primary data sources, which are our physical device, our cloud storage, and our compliance data, which we've talked about in the other 2 sessions, we're going to take it from the presentation side of it and look at it at 2 different areas. So we have the client area and then we have the court area. So it depends on what type of case you're doing, obviously, and what side of the case you're working on and what type of presentation you're going to end up doing. I'm going to cover some of the basics of how do we take all this data that we put together and correlate it into something. And then I have Dawn and Greg with me that they're going to talk about 2 other approaches. Dawn is an attorney, so I don't even have to do the pretend I'm not an attorney thing with all of you, so that's a bonus. And then I have Greg, who is part of the Paraben team, who does a lot of our digital consulting, and he also does a lot of our testimony work. That way you can get multiple opinions in this particular area. So one tiny little housekeeping thing for everyone, because there are 3 different presenters, you guys are going to put questions into the chat area inside of the platform we're in, and then we're going to answer them all at the end, because we'll put all 3 of us up on the screen at the end to answer questions. I think that will be easier than looking at them in context of those other sections. So let's talk about first our clients. So these are my opinions, and Greg or Dawn might have different opinions at the end of the day. It's why I brought 3 people in for this particular sections. So when I do consulting work, I like to keep it simple. And the reason is I know I'm always going to have multiple drafts of a report or what type of output I'm going to do with a particular client. So I try to keep it to direct points of interest based on what their requests were to me. And I try not to overcomplicate it with a whole bunch of, I'm going to call it like that nerd talk. And the reason for that is that's not why they're hiring you. You're already established as someone that is a valuable resource to their organization. So you're not trying to prove yourself in your report. You're really trying to make sure this is the data that you have, which your objective was this. That way you're prepared, so if it does end up going past one level within an organization to maybe the next level, you can make good executive descriptions or summaries or have different meetings with different tiers of the people that you might be working with as clients. In the end, you might potentially go to court, but a lot of times the details that you were sharing are spent with that client for a lot longer than it's going to be spent with that court. So I think explaining something that is technical to a non-technical person is a very important skill to have. So this is my best explanation I have of it, because I've used it multiple times, and I don't share the little emoji, obviously, when I explain it with clients, but I think this is a perfect example. Cloud in and of itself is not necessarily a complex architecture or topic for people, but they think of it as something crazy complex. And the way that I test this is I actually talk to my mother. She's in a different generation than I am, of course, and she's in an older generation that isn't super nerdy or in touch with their nerdy side. So I know if I can explain it to her, I can explain it to anyone. But when I talked to her about cloud, I was given this little icon and it said, there is no cloud. It's really just someone else's computer. And when I sat and I explained how cloud data worked to her, and I referenced it as, this is simply a computer that you do not touch and you do not see, but you're connected to. She's like, oh, okay, so why do they call it cloud? And I said, it's not because it's existing in the cloud or it has an elevation, or she had a whole lot of assumptions about cloud that kind of made me laugh just a little bit. But at the end of the day, telling her that it was really just someone else's computer and then keeping that explanation extremely simple allowed her to understand where that data was and how it got generated from her mobile device, as an example. So this is an important aspect of when we get to that presentation stage of all the different data points that we've collected, because potentially whoever is reviewing it is not really going to understand what cloud is initially, or they're not going to understand what compliance data is initially either. And you're going to have to take those times to sit down and say, hey, let me explain this to you. Understanding that it comes from a direct device is obviously much easier for a person because they have it, but getting through all those other little idiosyncrasies that make us digital forensic people can be somewhat challenging. That's why we end up having reporting. So reporting is something that I think a lot of people take for granted, which is kind of funny because it's really what your work product is at the end of the day. This is what shows your potential client, as we're discussing this area, what data you've been able to find and produce that answer the questions that hopefully you asked them in the initial stages of your process of getting hired as a consultant. So first things that I bring up with them is I say, here are my primary tools results, and here are my secondary tool results of the primary data sources that you requested. Or I say, I found the exact same data and it was reproducible. I had no problems or differences between my two different tools. So make sure you emphasize to them that you are following the proper forensic procedures associated with it. I love pictures because I am a visual learner. You guys have probably figured that out at this session because I've had a lot of visuals for you. But I think it is a great way to really instill a very complex topic, as is an analogy. Whenever I explain how the file system works on Apple or an Android, I always use an analogy to do that because it makes it a lot more relatable. Your goal is to make sure that they understand directly where the data came from and then how you potentially got it. And it might be, I used a software tool in order to capture this information, and that tool produced this type of data. That's a perfectly acceptable explanation for it. But then you want to say, I've also gone through that extra forensic step that says I've also done a second verification of the data to ensure that this is 100% accurate. I know that this is the primary data for your case that you're interested in. And I think pointing out those extra points that you're doing are really making sure that you are going to be the best possible expert available. The last little section I have is really that there is never a final draft. I think that I've had some cases where they end up generating probably 10 to 15 different reports is they're like, oh, I want to learn more about this. I want to learn more about this. And depending on how you set up your pricing structure for your consulting, it might fall within your original consulting rate or go to additional. No matter what, just view them as drafts and always offer, say, I'm happy to dive in deeper to this particular data. We can do a specific report associated with just this information. Be flexible with whoever you're working for because, again, they're seeing this raw, naked data from a smartphone that they have never seen before. To them, it's just this beautiful, handy little device to them that has a bunch of stuff that makes their life easier. They never look at it from that raw standpoint that we do in forensics. So really understanding, looking at maybe a spreadsheet of text messages versus looking at them in WhatsApp, it's a totally different experience. And you have to kind of guide them through that process. So now I am going to hand it over to Don to talk about the courts.
Okay, can you hear that all right?
Yes, hang on 1 second.
Okay, just making sure.
Yep, I am.
Oh, check that. Oh, I know what happened there.
Sorry about that, guys. I am going to open my camera just so I can still share the screen. I know. We've all got
right. Yeah, we got right in front of the infinity. That's kind of nice. I like that.
There you go.
Thanks a lot. I appreciate the opportunity to speak to you guys and to give you an idea of slightly an idea of the differences between talking to a client and giving the results of smartphone analysis to a client, as was brilliantly explained by Amber, and doing the same thing in a court scenario. And one of the overviews one of the points I want to make sure that you come away with is as follows. In order to get to, and can you go ahead and just kick the next slide, Amber? In order to get to court, in order to get to court, in order to get to court to testify, generally speaking, you're going to have to write a report. And then there are 3 hurdles you're going to have to overcome in order to get there. The first is you're going to have to demonstrate in the face of a challenge by the other side, you're going to have to demonstrate that you personally are qualified to present the information and to explain what you've done. So there's a personal qualification. And that can be by experience, education, training, etc. One of the things that's a nice example is you can become an expert in fly fishing or deep sea fishing if you fish a lot. And so you don't need to have formal education, a lot of degrees on the walls, although those don't hurt. But you do want to be able to present a certain degree of proficiency and understanding of the knowledge domain called digital forensics. I would expect almost everyone ought to be able to demonstrate that they're either certified or qualified to do the work. But when we end this little first 10, 15 minutes of overview, I want you to note that the certification that we all got back in the day, or the certifications that different manufacturers of different tools give out, or the certifications that are tool neutral, there are lots of certifications out there, and you can count on the fact that in the next few months and the next few years, because of changes I'm going to explain to you in a moment, those certifications may be challenged, or you may be challenged to explain why is your certification that's 10, 15 years old, why is that still valid? What does that mean? And that is because the challenge to you personally is to demonstrate that you still are proficient. A little bit like a doctor that might be practicing for 80 years or something like that, might be able to say, well, I'm really smart because I've been doing this for so long. But the flip side of that is, well, what makes you still proficient in the new technology, et cetera, et cetera. Can I get the next slide for a second? The second thing that we've got to hurdle is going to be, all right, I understand you know what you're doing. That's great. But what scientific principles did you rely upon or use to come to the conclusions in your report? Now remember, this is important. When you're talking to a client, the written report is what you leave behind. The written report is what you explain. In a court system, the written report is a thing that the judge usually gets, not the jury, the judge gets. You get to use the report and sit on a stand holding it if you'd like. Pieces of the report may be displayed on a screen, but it is your testimony that goes in the record. If you've got a report that's got 15 points in it, and the attorney that's asking you questions about that report does not ask about all 15 points, maybe asks about 10 or 12 of them, the points that you did not verbally testify about do not enter the record and are not evidence. So let's think about this. We, therefore, when we write a report, we want to make certain that the attorney that's going to conduct the direct examination of us in a court has been properly prepped to make certain that the attorney covers all the points in the report so that we get through our testimony the points in the report into the record. That is really important. And if you think that clients don't understand a lot, or as Amber points out, if a lot of people think this phone is just a funny device or a convenient device, attorneys are not only that naive many times, but many of them are very technophobic. And so it is incumbent on us as the expert to not only write the report, not only know that we're going to have to testify about that report and qualify ourselves, but my recommendation is, and I do this all the time, I write out the direct examination I want the attorney to follow. I write out the questions. I write out the bullet points under each question, what I'm going to testify to. And I work with the attorney to get the attorney to the place where they can smoothly walk us through the report. Now, why is that important? It's because one of the first things that we're going to have to do, both in the report and as testifying, is we're going to have to show to a judge many times before we ever get to trial, before we're ever on the witness stand giving testimony. We may have to show to a judge in either a motion called a motion in limine or a challenge called a Daubert-Frye challenge, saying you don't have the right to testify because either you're not an expert or because the principles that you're applying are not valid. So the second hoop after, are you an expert? Are you qualified? The second hoop is, are you using legitimate, reliable principles? Reliable principles. And why has this become an issue? It's because our brethren, primarily, our brethren and sisters, primarily in the FBI, and I say this because I love them all, have testified in the past to so many things in an area called pattern matching. Pattern matching is an area of expertise where someone testifies, as we're seeing here in this slide, someone testifies that I can look at a video of a set of jeans that are on a video of a bank robber, and I can zoom in and I can look at the seam and I can look at the wrinkles and I can look at how it's dyed and faded, and then I can compare that to a set of jeans retrieved from a suspect's home. And by carefully comparing the wrinkles and you can tell how much I believe this stuff, the wrinkles and the tie-dyed and the little dewatches, and coming up with a whole language about what we might call these little wrinkles, I can testify as an expert, as has Agent Brugge testified in experts, that this is just like DNA, and therefore the likelihood that the pair of jeans that we got from the suspect's house is not the pair of jeans he was wearing when he robbed the bank is 1 in 6 billion or some other silly number. This type of testimony, since it was so, this type of testimony in both fingerprinting, DNA, tire tracks and tire imprints left in the mud, burglary tools and marking tools when people break into things, bullet striation marks, etc. In pattern matching fields around the country and in different cases, people testified in such a way that there was formed a commission that looked into the reliability of this kind of testimony and came to the conclusion that this kind of testimony was not nearly as reliable as people thought. Can I get the next slide, please? Was not nearly reliable as people thought. And the Presidential Commission on Scientific Testimony came out with a report in 2018 that was really, really, really critical of this kind of stuff. And it basically said this. It was really easy. Think of it this way. It basically said, if you're asking people to compare things, it's a little bit like a multiple choice question. If I give you a multiple choice question, I say, is the answer A, B, C, or D? Many people might be 98% correct at choosing what the correct answer is. But if I say to you the answer is either A, B, C, D, or E, all of the above, or F, none of the above, accuracy really drops. So if I tell you compare 2 bullets, and I give you 1 bullet and 5 samples, and I tell you this bullet matches either sample 1, 2, 3, 4, or 5, or it matches all of them, or it matches none of them, and then I compare your accuracy rate, things really kind of fall apart quickly. That led to this type of analysis. The commission was formed. The commission recommended lots and lots of changes to the way experts testified. They came to the conclusion that in the area of forensic examination, and that the same rules apply to the area of digital forensics, in that area, when experts testify, we've got to make certain their testimony is reliable. Can I just get the next slide? And in order to do that, Federal Rule 702, which is the rule that allows us to testify, this is the rule that says basically you're allowed to testify if you're qualified because of your knowledge, skill, experience, training, or education. You can testify. You can testify about what opinions you've got in the report. Yeah, you're allowed to do that if you can show the judge, not the jury yet, if you can show the judge that A, your testimony is going to help the jury. It's easy. 2, it's based on sufficient facts. All right, it's not just guesswork. 3, that your testimony, your opinions are based on reliable principles and methods. And the last loop, that you have accurately and reliably applied those methods to the facts of your case. And just like Amber said, using two tools to get to the same result, that goes to the reliable principles and methods, because you can count on the fact that people like me on the other side, or people like me when I'm helping clients and I meet a good forensic expert on the other side, the first thing I'm doing is looking at that report, and I'm looking at their process and procedure. I'm looking to see ways in which I can set, in which I can ask, what was the scientific principle upon which you relied for this conclusion? What was the method you used? How do you know that method even works? What results are you looking at? What studies have you read? Next slide for a second. And if you can't demonstrate that it's more likely than not that your expert opinion on the matter is based on reliable digital forensic principles and methods reliably applied to you by the facts, you may not ever get to the case. And the fact of the matter is, in our industry at the present time, this is not easily done. Let me get the last slide here real quick. And that is because if you think of it, it's not easily done because we don't have a lot of infrastructural support. There are over 60 documented forensic processes that people advocate. Well, here's how you should investigate. These are the steps you should take. There are all kinds of them, but none of them have tested themselves out for reliability, validation, etc. So, for example, if you were asked, cite peer-reviewed studies demonstrating that your method, whatever method you use, that your method's ability to reliably associate digital artifacts with specific sources in the real world. Can you do that? Link file analysis, perfect example. I just testified last week in federal court in Chicago, basically on a report that was heavily reliant on link file analysis. And I did that link file analysis with 3 different tools because the opinion was really going to hurt the other side. And I knew that attorneys alone were going to say, give me a break. What do these link files mean? How can they be changed, et cetera, et cetera? What's my error rate? What's the error rate of the tool? And secondly, what standards are we working towards? Is there a NIST standard for investigation? There actually is. Is there a NIST standard for tools? I know Parabin and Amber are very familiar with the computer forensic tool testing division of NIST, et cetera. All of that knowledge domain is currently on the table. If you'd like to testify, just be prepared that the process you use, the tools you use, and the application of the principles that you use properly applied to the facts, that is what is in your future like never before, because the rules that I just read to you only changed in in I think November, December of 23, and they're only now making their way through the court system. So I thought you'd like that. Did I scare Amber away?
Yeah, I'm here. I had that, like, hang on one second. So that, I think, is a very, very important aspect, is how much it is actually changed for now, which leads us into our next section as well, which is the use of AI. And we have to talk about that because everything is using AI at this point. I feel like you cannot turn around and not have an AI abuse. So we're bringing in Greg Kipper for this one. Go ahead, Greg. I'm going to just tell me when you want next slide.
Okay, thanks, Amber. Okay, let's. So picking up on Don's momentum, and everyone on the call, I'm certain is well aware of the realities of AI and what is coming. So let's dive in for a second. Go ahead and go to the next slide. So I'm going to talk about 4 areas, and I'll just start with customized documents. And Don and I coordinate on this, so this is really meant to emphasize his points, and particularly using AI, and particularly generative AI, to really enhance your capabilities, as well as keep you out of a lot of the pitfalls that he mentioned. So for those of you that have used it extensively, this will not come as a shock, but if you're new to it, then let's talk about some of the things that matter. So what Gen AI can do for you from a personalization standpoint is you can now quickly personalize documents, simple stuff, verify them for spelling, factual accuracy, things like that. So it makes your case and your evidence a lot more specific to what you're actually working on, just like you would when you would normally write a report. Some language optimization. This is also very helpful. And having written hundreds of reports in my career, probably thousands, you adjust your language for the audience. So you can, just like a really powerful thesaurus, it can suggest alternate wording, to ensure clarity on certain points, to avoid ambiguity, and in some cases, avoiding terminology that may, create even further problems, keep you off those proverbial slippery slopes. Then we got compliance checks, and this you can use AI to really ensure that the documents that in reports that you're working with or the evidence you're reporting with adheres to any of the most recent laws and regulations. To Don's point, this is really specific. And so all of this combined, can allow an attorney, to present their arguments, that are more likely to resonate, effectively with a judge and, or a jury. And that's in the end, the ultimate goal. Okay, go into the next slide. So talking about predictive analytics, getting a little deeper into this, so some case outcome predictions. Now, I've used this, and Don and I have talked a lot about this recently, and in a lot of the initiatives that we're doing here at Parabon. But we can actually take a case, and with the information that's available, and with what some of the AI tools can do, we can say, all right, let's look at every case, because that's now potentially practical. If it's documented, if it's in digital form, it can start to give you a pattern that you can say, well, given these conditions, what's the likely outcome? And you can start to get a much better insight. And so it's a huge time saver, because you could do this all manually. If you had a year to do all the research, you could absolutely arrive at the same conclusion. But now that year is reduced down to, in some cases, minutes or hours. So very handy there. Early case assessment, same kind of thing. Can evaluate the viability of the outcome. Hey, do you have a strong case or not? And this can help, help with understanding an attorney's position or strengths or weaknesses. Then it gets into, behavioral analysis. Let's look at a judge's past rulings. Are they risk adverse? Do they, are they heavy-handed in this certain area, or do they not understand this certain type of technology? And those insights matter. And Don can weigh in that later, but I'm sure he's nodding his head vigorously of that. Certain judges, if you don't present this the right way, because the judge is just a human being with with their strengths and biases, just like everyone else. So better to have a tailored approach that helps with your argument and strategies. Same thing with settlement negotiations. Let's look at the key factors that could influence a settlement outcome, and see if you can guide the case to or guide testimony or whatever to kind of point to the direction that you want it to go. And then jury selection, another big one. Let's look at demographic and background data of potential jurors to get a better idea of what their preferences or biases might be. So, lots of capabilities there. Next slide, please. So let's look at enhanced legal research. And I touched in on that on the previous slide. Some of these have some overlap. But, rapid information processing. Gen AI is perfect for analyzing vast amounts of legal data, case law, statutes, literature, all of these things that, would require, tremendous amounts of time and, and detailed analysis to put together. There's plenty of services and specialized tools out there, but it's a resource that is in existence today, and this is definitely not going away. Intelligence summarization is another nice one. I use this every day for not just legal things, but for a lot of stuff. I need a really good summary of a complex legal document or something, let me make sure I don't miss a point on critical arguments or key points. The summarization can make sure that you don't miss anything, so you can take that and you become the human in the loop and fold your decisions and the context back into it. And then, of course, an easy one, multilingual support. You can have case summaries in multiple languages, if you need to. So next slide. And then my last slide, that really lends to this is audience-specific language. And I think this is going to get more and more interesting as the months and the years pass as we go forward, particularly with legalese. And not to call out Dawn or to pick on attorneys at all, but a lot of times, this is actually a known thing that attorney language, the complexity in which they speak is actually designed as a barrier to entry. It's meant to confuse people. So it's like, well, if I can understand it in plain English, why do I need an attorney? So that is something that has evolved, from since attorneys first started out as kind of a way to, add additional value. But as the law has grown more complex and as a lot of these things become, very intricate and difficult to understand, AI now is really good at just, hey, explain it to me like I'm an 8-year-old, make sure I understand this, and it can cut that away. Now, from your perspective of I'm giving testimony or I'm putting a report, you now have that ability to adjust your writing style to the audience. You can make it formal and respectful, for judges. You can make it more conversational for peers, or you can make it in plain language, for clients or for witnesses, for the jury. So it can be the same message, but in 3 different tones, and it adds to your overall effectiveness. Again, kind of, tone is same as the plain language. So I've already kind of covered that. And then you can balance your precision and accessibility. So you can ensure that you're speaking precisely, because legal terminology is very precise for just that reason. But you can find that nice balance point pretty easily between legal precision and readability. And this is also good, when you're writing for non-legal professionals. So that's my last slide, and I will turn it over for questions.
Now, 1 second. Let's pop back into the group. All right. So that should put us all back in here. There's some good gifts happening. So let's go over to the question and answer. So the first question we have is, what kind of testimony is used most often in investigations? Oh, Dawn, you're on mute.
Did they ask what kind of testimony?
Kind of testimony is used most often in investigations.
Well, on the stand, all testimony, if I understand the question correctly, all testimony coming from the expert is quote, expert testimony. It's not fact testimony. You are not a fact witness. You are an expert. So the scope of your testimony is delimited by the scope of your report. The focus of the testimony and the opinions have to be in the report. And then you've got to actually give the testimony. And the testimony on the stand has to match the testimony in the report, lest you get an objection and that testimony gets stricken. Does that help?
We'll see if they have a follow-up on that one. Our next question we have is, can AI be a challenge when ensuring a correct report? How do you deal with the hallucinations, probably? Absolutely.
So, quick background. AI does not understand English. In a short answer, it's very. It has a lot of capabilities. The neural networks, can understand context and a lot of very sophisticated pattern matching. But yeah, a hallucination can occur where it wants to give an answer, but it may sound plausible, but it could be false information. So this is where it comes back to you, the investigator, to double check. You know, if something doesn't seem right at all, you know, make sure, you know, verify with different sources, ask it to explain it a different way. You know, I had this, you know, earlier today when doing some research, and it gave me a, you know, hey, here's a testimonial from somebody. I'm like, this person doesn't exist. I guarantee that this is not a real testimonial. And it certainly wasn't. It was, you know, the AI wants to say, oh, you know, because you asked me this question this way, I want to support it with as much information as I can. So when it, you know, it's a fantastic tool for distilling, you know, really good information that is contextually relevant to what you're working on in that moment. But you as the human are still the, you know, the smartest thing, you know, in that situation. And, you know, your judgment and your experience and your ability to double check is what's really going to matter.
And let me jump in and just add to that, because it's an excellent point. I use AI to try to identify any internal inconsistencies or contradictions within the report. Uh, I'm really not interested if they run out. I don't want to run out to the internet and tell me stuff, but I would like it to be able to go through the report and make certain that I haven't said something in the fact area that has been contradicted later, or I changed something. At the very minimum, I want a report that is internally consistent. And I know that in talking to Greg about that, I do think AI is helpful in that, in making sure your internal consistency, or there are no internal inconsistencies.
I think AI is definitely a great tool to have. It's almost like a, you guys can't see it. I can turn my camera on. Here you go. It's a peer review in a way for that same reason. It gives you the ability to have that when you don't necessarily have a second person that might look at your data. Another question. For those who are not comfortable with testifying, can you explain how an expert may still assist in an investigation to uncover new facts or facts in dispute that were turned over in discovery?
Sure, that's really easy. You get engaged initially as a consulting expert. The rules of civil and criminal procedure indicate that consulting experts cannot be compelled to testify by by deposition, subpoena, or otherwise. So a consulting expert is obviously what you want to be initially, because you may, and frequently may do, come to opinions that they don't want you to testify about. I do a lot of criminal cases, and a lot of times I come to the opinion that the criminal defense attorney goes, yeah, we had a hunch there was no way out of this, or whatever. So they don't want me to testify and in effect go on the stand and validate what the prosecution's doing. So begin as a consulting or consultative expert. And then after you've given them your opinions, and we all agree on stuff, if they are helpful, then you can be designated a testifying expert. And now going forward, the report would be discoverable, et cetera. But work product ahead of time, if you're just a consulting expert, not even discoverable in the civil case.
Do people need to change what their engagement letter is to specify that, or can it just be you're assuming that you're entering in as a consulting expert?
I don't like to assume anything, because there's always attorneys on the other side whose job it is, like mine, to see if we can't figure out a way to mess up your life. But yeah, put it in the contract. It's real simple. A little extra paragraph. I'm initially being retained as a consultative expert. Should the client decide to designate me as a testifying expert, then, and by the way, you can do a fee change at that point. Once you're designated a testifying expert, you've got a reputation to protect. You've got past opinions. You want to make sure that if you've changed your mind, you're going to have to explain why, and you've got the potential of future testimony. So getting from consultative to testifying expert is a leap, and I charge more.
No, that absolutely makes sense. I know that even in our agreements, we also charge more if we end up doing expert testimony as opposed to just doing work. So that's a good rule of thumb for everyone doing that type of work. Okay, let's see if there are any other questions from anyone. I left more time for questions today versus our other one. You guys can also bring up, since you have three, I'm going to call us all experts, 3 experts in one session, that you could ask questions about if you were part of the capture session or on the analytics session that were done earlier in the month. You're welcome to ask questions in those areas too.
I'll offer, as you're thinking through, a way to differentiate your practice, and I think more and more of us are going to have to, way to differentiate your practice from the mouse jockeys or the button pushers is to get behind the tool, to understand what the tool does, to ask the manufacturers of tools for more and more and more transparency. And I would recommend everybody take a look at what the FBI did in order to create a thing called torrential downpour. That's TORRENTIAL, torrential downpour, where the FBI hacked a torrent client uh, so that the client could go out into the internet and enter a Tor system and not and once connected to somebody like the old LimeWire, once connected to somebody, instead of giving up or having to share pieces of files, it allegedly stays connected and does some stuff to capture IP addresses on and on and on in order to support usually a search warrant and subsequent prosecution for child exploitation material. In those cases in which I've got a chance to see the type of reports generated by the torrential downpour, it is a hacked client, a hacked torrent client, and maybe our whole industry could stand more hacked tools. We could maybe have more fun trying to bust into stuff because the FBI has shown us, yeah, you bust into something, you figure out how to make it do what you want to make it do, and then, then what? Well, the FBI gets to say they're the FBI, so I don't think they're challenged as much as they should be. I certainly go out of my way to make sure that the poor person on the stand is asked all kinds of questions about how that tool works that nobody appears to have peer reviewed, perhaps. And again, now you're asking the questions before they ever get a chance to testify. Weakness in the area of knowledge of the tool, knowledge of the process, can't defend what you've done based on scientific principles could easily lead to the exclusion of your testimony, or the exclusion of the other person's testimony, which is a win.
Very good points. Have you noticed, Don, this is my question because it's a good one for all of us. Have you seen a distinction in the US courts between verification and validation of the tools? I've seen that from other countries, that they're really making a distinction that as an examiner, I have a requirement to do a verification of my tool in that particular country versus a validation of it.
Yeah, I think, in fact, a lot of what I'm reading now is coming out of the UK.
Mm-hmm.
They're really focusing on validation and reliability in terms of testimony. And my at least understanding of some of their approaches, you got to be using tools that have somehow passed some kind of minimum test that says, yeah, the tool works, it does what it's supposed to do. But then you've still got to demonstrate that the tool you used produced a result, and then you did something else to prove that the tool was working when you used it. Is that your understanding as well?
Yeah, that's how I've seen it as well. It's been a long time since we've seen another country really push that line. And I definitely am seeing that in the UK. We even saw that in the last couple of weeks, going back to our capture side of things, guys, where the UK government got Apple to change its permissions to allow them to capture data out of the iCloud.
Well, and indeed, how fascinating is that? Apple, when faced, at least Apple did the following. When Apple was told in the San Bernardino case here in the United States that they're being sued by the FBI in order to create a government OS that would let them into the Apple system, break the encryption, Apple fought them, and right on the eve of trial, the FBI found a way to crack into that case. And there's all kinds of neat stuff written about where did that result come from? Did it really come out of Israel? Did it come out of the state of Washington? On and on and on. Some great articles. In any event, so Apple says to the government in the US, I'm not going to let you into my iOS. In the UK, the LA law enforcement wants the same thing. And so Apple says, look, here's what I'm going to do. If I cannot keep you out of the iOS, if you're going to demand to be in here, then I'm just going to make it so that the stuff in the iCloud is no longer encrypted, and you still don't get into the iOS. But now all you got to do is enter the iCloud, because we no longer offer encrypted data on the iCloud services coming out of the UK.
Yep.
So it'll be interesting to see if they're ever forced to build an iOS.
Yeah, it will be very interesting to see what happens. And that literally, I think, was in the last 2 weeks.
That's correct.
It was crazy. I never expected not that Apple folded, but so much as they were actually flexible, that is not something they're known for.
Well, they've tried a few things. If anybody ever wants to read what was Apple's idea about a year and a half ago about child exploitation images, about an on-device read of the image, and then in effect two images in a sense, or an on-device read, a little bit of extra metadata, send it up to the iCloud where an Apple server reads the information and makes a determination whether or not that image already violates child porn laws. And they pulled that off. The big uproar, but fascinating to read. I got a whole seminar on just how that was built, and an attempt to accommodate law enforcement in certain areas. And then, as maybe Greg will point out, right on the horizon is the fall of encryption. If something doesn't happen, AI is going to get powerful enough that doesn't matter if you've got it encrypted. We'll be able to decrypt it.
Absolutely. I think that whole argument where with the whole process of decryption, where you're really fighting over the size of a key space in X amount of time to be able to process that key space, with the use of the GPU and with the use of AI, that math will all of a sudden fall in our favor. Where right now it's 4 times to the end of the universe, it will be like, no, it's 20 minutes. I think that's absolutely on the horizon for us all.
And it's a certainty once they get quantum computing to the place where they can do it so much faster even. And that'll, I don't know if it'll come in the rest of my lifetime, but it'll show up.
Yeah, I expect it as well. It's definitely a shift in our industry, so those are things to watch for.
And to get back to a little bit to differentiation, if you guys take some time to study what other hoops that we talked about briefly that you got to go through, emphasizing the fact that engaging me, like it's I am prepared for these things. Not only am I prepared for these hoops, I'm going to make sure that our side's got the hoops down pat and we do a great job. But if the other side hires an expert and they've got any of those hoops not well covered, we'll be in a better position to attack them because we're thinking ahead.
And I think that's a huge part of it as well. You guys heard in the other sessions, the other thing is making sure that both sides receive the same information. I think that's a big problem that's happening, where we'll see an image produced by one side and they say, well, the other side, you just get a report, that's it. And you get nothing else. But they don't get access to the device, they don't get access to the image. But a lot of times you guys just don't know to ask, to demand that you should be able to get that information as well. So make sure you're paying attention to that. That was that whole AI part, I think, where Greg was saying legalese had that natural barrier to entry just on how it is phrased.
Well, and there is a whole world of gamesmanship in which if some bozo decides I'm going to give you an image and it's not the same image my experts got, it is true from a forensic point of view, well, how dare you? I want to see the original one. A more sophisticated response would be, wait a minute, let me see what I can see off of this image. Because this might be the better image.
And that might be the one that you're like, this is what we're going to work with, people.
Absolutely. And we're going to move to make the other side, because you got a different one. You're not allowed to just say anything about the different one because it was your obligation to give it to us. So you might have a strategy that doesn't even ask for it until the day of trial, in which you feign absolute shock.
There's always strategy. There's a gamemanship.
Oh, yeah.
Absolutely. All right, do we have any more questions from the group? We've gotten a couple others. Those of you who, Don is actually presenting at both PFIC summer and fall this year, and so you'll see similar topics to this. He's one of my unicorn lawyers. I know I have a couple others. He's like a unicorn Pegasus. I actually have one in the back of my office now because I have to reference it. That says, he really understands not only the nerdy side of it, but the law side of it, which is fantastic. So I often send him questions. I'm like, well, what about this? What about this? Just to kind of brainstorm through some of those. And
I just use AI, and whatever it tells me, I just keep it. I got no idea. So, hey, a good printer. No, before you knew it, I had a law degree. So,
Don, I have one more question from someone. So, have you ever filed an MTC when the data was acquired several versions ago?
Have I ever filed a what?
MTC. You might have to define that acronym, Drew.
When the data was acquired several versions.
Motion to compel. Thank you.
Oh, sorry about that.
Yeah.
Oh, sure. I mean, and what were you trying to compel again? You were trying to compel data that what?
It was acquired several versions ago from the current release version of probably the
Oh, to be perfectly blunt, uh, think of it this way. In my opinion, uh, the world is just full of data, so you can go crazy trying to chase it all. And when we first started forensic stuff, there really was a theory. It says, "Give me all the devices, I'll image all of them." You know, you got yourself a 25 gigabyte hard drive.
It was
We could do,
500 megabits. Yeah, it
or
was,
you got, or I remember even zip drives.
yeah,
Ooh.
zip
So
containers.
in any event, so today there's a pretty strong demand that says, okay, we got all this stuff and we got versions of stuff. We got data that's archived. We got data all over the place. Generally speaking, if you're going to go in front of a stranger called a judge with a motion to say, hey, I want these guys forced to do something, you need a good argument that says, why should a layperson understand that in your way of thinking, it's more likely than not that you have identified a source of relevant information that you need to get to? Uh, and you don't want speculation, but that challenge is, to be honest with you, the same as when you listen to a client in your first meeting and they describe they've got 3,500 employees, they got 4,000 endpoints, et cetera. And what are we going to do? And you are in your brain going, well, I don't need to talk to all of those 3,500 people. How are we going to delimit stuff to that which is reasonable? Tell me more facts. I'll tell you who the witnesses are. And then tell me how they work. And I'll tell you whether or not we ever got to get to their home computer or not. Or tell me they got an iPhone. And I'll tell you, if you want to do something maybe less invasive, do we look at the cloud first and then the phone, et cetera, et cetera, et cetera. So it's kind of what we do. The motion to compel is something that needs to be based on an analysis that says we've identified a target that's reasonable.
And that's one of the reasons that I recommended early on in these series. You guys really track your tools that you use, track their release notes, but also track the release notes of the systems that you're investigating. So Apple is putting 18.3.4 out. So you need to know if something potentially is not going to be covered in your tool and you have a delay of maybe 6 weeks before it gets accepted as processed. So those are things you want to keep track of. So a target, that one might need anonymous. Target is identified based on which factors? I need more. I don't get that one. Rephrase, pull it into AI, get a better phrasing. Yeah. I'm like, I don't follow that one. Happy to answer it. Happy to get us to answer it. But yeah, something to keep in mind. There's a lot of documentation, I think, that we as examiners fall behind on that makes us prepared to be able to be on both sides.
Yeah, and if you can anticipate what the other side's going to say and do, you're in such better position, because you can write your report to indicate, I've thought about these other things and here's why they're not true. Well, that's hurting the other side before it ever starts.
Yep, good strategy. All right. Well, I'm not getting a rephrase on anonymous. No.
It's one of my FBI friends who are trying to. All right, you. I'll give me a bad time, will you? It's the guy with the jeans.
Okay, yoga pants just destroyed.
There you go. He completely destroyed his career.
Rob a bank, do it in yoga pants, people. You don't have that seat analysis. That was crazy. All right, if we have no other questions, we appreciate you joining us. I know the recordings for all 3 sessions will be available after through Cyber Social Hub. So you should be good to go. I know you'll get a notification about that. And we look forward to seeing you in another session one day. So thanks so much, everyone, for joining us.
Everybody have a good day.